Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we are going to talk about what a person in their 40s might typically need for an estate plan. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on my social media. I'm at Amanda Rocha Law. Just as a precursor, every person needs something a little bit different. There is no one-size-fits-all estate plan, but I'm going to give you an example of what a typical person in their 40s who contacts me might need as an estate plan. First of all, most of my clients who are in their 40s, if they have children, their children are either teenagers or approaching teenage age, although I see the trend of people with younger children at that age. So I think the most important thing to my clients in their 40s is making sure their children are protected if something happens to them. And as a parent myself, I completely understand that. If you have minor children, then having a guardianship declaration is important, but also having a revocable living trust helps your trustee in the future be able to handle the property that you have on behalf of your children until they reach whatever age you think that they should inherit it. Can't be under 18, but it could be 25, it could be 30, it could be 21. You get to make that choice. However, if you don't have something set up in place like a revocable living trust, then their property will be given to them when they turn 18. And that's not always the best idea. If they are over the age of 18, it's important that your documents reflect what you want done with them. Either if they just turned 18, and like I just mentioned, you want them to receive inheritance when they are 25, 30, or in a tiered structure like that if something were to happen to you, or you might need to update your estate planning documents to name them as your trustee if you're choosing to do that, or include their children for specific gifts, that kind of thing. So we want to make sure that your revocable living trust is up to date and giving them what they're going to need when you aren't there to do so. Something that everybody needs, and I've mentioned this many times before, if you don't already have an advanced healthcare directive and a durable power of attorney and a HIPAA authorization, these documents are used to make sure that when you become incapacitated, somebody can step in and make important healthcare and financial decisions on your behalf while you're incapacitated, and then as soon as you regain capacity, you'll get your powers back to do everything and your power of attorney loses their power. That's called a springing power. This avoids any kind of unnecessary court hearings and conservatorships from having to take place if you become incapacitated. If you have a living trust, you will need a pour-over will, which is a document that basically handles your personal property when you pass away and transfers the title, well, not title because there's really no title to most personal property, but it transfers custody of your personal property from your estate to your trustee and allows your trustee to use your trust as the main document to distribute that personal property. You may also need guardianship declaration, like I mentioned, but you may also need something for your pets, so we can include that. If you're a business owner, we can decide, depending on the way that you own your business, how to handle that in your trust and how that will wrap up if something happens to you. Business succession planning is important, and many people never even consider the fact that something, when it happens to them, also happens to their business. So that's going to be something you also include. And if you've been married and divorced, or you are remarried, or even if it's one and only marriage, you have to make sure that your spouse is planned for as well. So all of these documents will apply to both of you. You each get your own for most of them, but you can have a joint trust if you are married. If you have stepchildren, that's something you have to consider. If something happened to you tomorrow and you didn't have an estate plan, your stepchildren would not be included in your probate estate. If you want them to be included, then you have to intentionally include them. If you have any questions about your estate in particular, please contact me. You can find me on my website, www.amandarocalaw.com. On that website, you can literally schedule a strategy session with me on my calendar so that I can call you on the date and time that you choose, and we can discuss your estate. You can comment down below if you have any questions, or follow along on my social media and comment there. I'm at Amanda Rocha Law. Thank you.